Good morning. This is the Colorado Energy and Carbon Management Commission. It is June 5th. It is 9 a.m. We will start our business meeting with a roll call.
Thank you. Commissioner Ackerman,
Here.
Commissioner Cross,
Present.
Commissioner McGowan, Commissioner Mesner,
Here.
Commissioner Oath, Commissioner Ray, Commissioner Robbins.
Here.
Mr. Chair, you have 4 of 7 commissioners present.
Very good. That is a quorum. Others are excused for their absences. We will start into an agenda. We start with commissioner comments. Does any commissioner have comments? Commissioner Messner?
Thank you, Mr. Chair. I wanted to update the commission and folks that are listening about an upcoming Colorado Produced Water Consortium meeting that's happening this Friday at the Adams County Human Services Center. There will be written public comment available, as well as folks who are interested in providing oral public comment at the meeting. At the meeting, we'll be reviewing a final draft of the current state of produced water infrastructure, storage, treatment facilities across the state, with an emphasis on the DJ Basin report. We'll also be looking at a first draft of the initial availability of produced water for reuse and recycling analysis. And then we'll be providing guidance on a proposed approach for an initial report on infrastructure, storage, and treatment facilities necessary to achieve different levels of recycling and reuse of produced water in different basins around the state. So looking forward to that meeting. Anyone who is interested in more information on that can find all the meeting materials on the Colorado Produced Water Consortium website.
Thanks for continuing the lead on that, Commissioner Messner. Any questions for John? Any further commissioner comments? Moving on to the consent agenda, we have 2 hearing officer recommendations under Rule 505. Are there any questions on consent? We have a motion to approve consent.
So moved.
Second.
Motion and a second to approve consent. All those in favor signify by saying aye.
Aye.
Consent is approved. Moving forward in our agenda, we have a Class 6 rulemaking presentation from Mark Seeley. He is the ECMC CCUS Geothermal and Underground Natural Gas Storage Specialist. If we could bring Mr. Seeley to the panel, we can hear from him.
Good morning. Can you guys hear me?
Yes, we can hear you.
Excellent.
We can see you too.
Perfect. Let me pull up my presentation. Let me know if you can see that.
Yep, looks great.
Excellent. Okay. Good morning, commissioners, and thank you for having me. My name is Mark Seeley, and I'm the lead CCUS specialist here at the ECMC. And I'm here today to discuss the upcoming Class 6 rulemaking we are set to initiate. My presentation will cover 3 main topics. We'll start with an overview of Colorado's CCS journey, including the background, timeline, related studies, legislative efforts, and where the public can access these resources. Next, I'll delve into a little bit of the Class 6 regulations, looking at both the EPA's existing regulations and proposed regulations specific to Colorado. And finally, I'll briefly outline the timeline for Colorado's Class 6 rulemaking process. Colorado's CCS journey essentially began in the beginning of 2021 as the state generated a greenhouse pollution reduction roadmap, in which carbon capture was identified as a potential tool that could support the state's decarbonization efforts. In mid-2021, the state convened a CCUS task force led by the Colorado Energy Office, and the task force was empowered to recommend policies and chart a pathway for advancing CCUS within Colorado. A couple key takeaways of the task force was, number 1, the ECMC is well positioned with our staff experience and background to be an effective regulator of Class 6 wells. And number 2, it encouraged the legislature to enable the ECMC to seek authority from the EPA for state regulations over Class 6 wells, otherwise known as primacy. Running concurrently with the task force and published at the end of 2021 was the first of what would ultimately be 3 Class 6 or CCUS reports. This report was an overview of the prerequisites for a successful Class 6 primacy application, or said another way, it identified the technical components of what it would take for the state of Colorado to apply for and be approved to have regulatory authority over Class 6 wells from the EPA. Moving into 2023, the second of 3 reports was published and dove a little deeper into the legal and regulatory frameworks needed for Class 6. Specifically, it identified gaps in state law or permitting considerations that would need to be addressed before pursuing primacy. Some of the big topics it touched on were around pore space ownership and aggregating property rights through unitization, among others. Also in 2023, on the legislative front, SB 23-016 granted COGCC authority to pursue Class 6 primacy from the EPA. Requires a cumulative impact analysis for all projects and requires a net neutral or positive impact for approval within a DI community. Gives local governments the option to regulate the surface siting of Class 6 wells in their jurisdictions, similar to oil and gas, and requires impacts to be avoided, minimized, or mitigated for all Class 6 wells. And it also implements a 2,000-foot setback from residences, schools, or commercial buildings. Moving into this year, the third and most recent study was published in February. The report aimed to advance our understanding of CCS projects, regulations, and their associated safety considerations from carbon capture to storage. The report provides an overview of existing carbon capture technologies, pipeline safety considerations. It reviews current Class 6 regulations and touches on considerations for communities regarding community engagement, environmental justice, and specific DI considerations. On the legislative front, HB 24-1346 addressed legal items that were needed for Colorado to effectively regulate Class 6 projects. Some of the most important items addressed were defining pore space ownership and a way to aggregate property rights through unitization, among other items. Lastly, we find ourselves in the present, in which we are drafting Class 6 regulations in preparation for our rulemaking later this year. I'd like to point out that all the reports and information mentioned can be found on the ECMC website. Just go to the homepage, click on the library link, and then select Geothermal CCS UNGS, which is underground natural gas storage. And I've highlighted the 3 reports that we published. Okay, let's transition now to talk about Class 6 regulations by first addressing the basics. What is a Class 6 well, and why are there regulations governing it? Class 6 wells are used to inject carbon dioxide into deep rock formations and are a key component of CCS technologies, which are aimed at reducing atmospheric or point source carbon dioxide emissions, helping mitigate the effects of greenhouse gas-induced climate change. Class 6 regulations provide a consistent and clear set of standards for the construction, operation, monitoring, and closure of carbon dioxide projects to protect public health and underground sources of drinking water. I want to point out that Class 6 wells are subject to the most stringent regulatory standards among all well classes, ensuring the highest level of safety and environmental protection during CO2 sequestration. These regulations provide a comprehensive framework to monitor and manage the secure, long-term storage of carbon dioxide. As we begin to dive into more specifics, let's explore the overall framework of the proposed rules. To start, it's important to emphasize our Class 6 regulations will be built on the foundation of federal guidelines, specifically 40 CFR 146 subpart H. We are prepared to adopt these regulations in their entirety, as achieving this alignment is a requirement for our state's primacy efforts, as states that are seeking primacy must have regulations at least as stringent as the EPA. It's important to note that these federal regulations constitute about 2/3 of the proposed rules and comprehensively cover major topics such as area of review, corrective action, site characterization, well construction, injection and operating plans, monitoring, reporting and verification, and post-injection site care and site closure, among others. Later in the presentation, I will dive into some of these topics in more detail. In addition to the federal regulations, Colorado's proposed rules will constitute the remaining 1/3 of our regulatory framework. The new rules will be a new series, Series 1400, and they place a significant emphasis on stakeholder and community engagement aspects, highlighting the importance of inclusivity, and transparency in the decision-making process. Specifically, these regulations address consultation and notifications, provide for local government siting authority, much like current oil and gas regs, provide additional siting requirements, such as prohibiting the siting of a Class 6 well within 2,000 feet of residences, schools, or commercial buildings. It's important to note adjustments to this setback can occur only after 4 Class 6 wells have been in operation for at least 4 years, reflecting a cautious approach to technology deployment. And finally, they address cumulative impacts analysis and an environmental justice analysis if the project is near a DI community. Moving along, this diagram illustrates probably a slightly different comprehensive kind of regulatory process than you may have seen for Class 6 wells, as I have delineated 2 categories of permitting requirements: stakeholder and community requirements that are mostly unique to Colorado, and technical criteria sourced directly from EPA guidelines. I would like to clarify that while the stakeholder and community obligations are not entirely unique to Colorado, their significance warrants a separate category for clarity and discussion purposes. Furthermore, I want to highlight how the proposed Colorado and EPA regulations intersect throughout the project lifecycle. Beginning on the far left, this represents potential operators or applicants who are engaged in their own proprietary project planning, including screening, feasibility assessment, and initial project design considerations. Upon readiness to proceed, applicants need to contact us to discuss project scope, data requirements, in alignment with other stakeholders as the permitting process advances. In subsequent slides, I'll go into more detail on these phases. Following completion of permitting requirements, projects transition to the pre-injection phase, which is characterized by data acquisition and finalizing plans prior to being authorized to inject. Subsequently, the project transitions to the operating or injection phase, involving reporting of operating conditions, testing and monitoring results, plan reevaluations as necessary, and compliance and enforcement through inspections. Finally, the project concludes with post-injection site care and eventual site closure. Going a little deeper into the stakeholder and community requirements, to ensure transparency prior to permitting, project notices will need to be sent to nearby surface owners, tenants, schools, child care centers, and first responder agencies, among others. Notices to relevant and proximate local governments and state and federal agencies like CDPHE, DWR, State Land Board. Prior to issuing a permit for a Class 6 well, the Commission will evaluate and address cumulative impacts from the proposed well. But the specifics of this analysis will depend on the outcome of the cumulative impacts rulemaking. So I think that's all I'm going to say about it for now. And finally, there are additional assessments required if a project is proposed near a DI community. And again, that involves performing and submitting a well cumulative impact assessment, as well as a community outreach plan, which should describe any measures taken to avoid, minimize, and mitigate adverse impacts to DI communities, including information regarding public meetings held by the operator and other items. Delving into the permitting technical requirements, we'll begin with site characterization, which involves conducting baseline studies on the geological, geophysical, geochemical, and hydrological data of the proposed site. Baseline data will also be gathered for future comparisons. Applicants will determine the area of review, which is the subsurface area where CO2 is computationally modeled to occupy, including a buffer zone that could see increased pressure as CO2 is injected. Corrective action plans are vital components of the process, serving as proactive measures to address identified risks and potential hazards. Effects on the injection and confining layers, ensuring the safety and integrity of the storage operation. Data collection, risk assessment, and mitigation within the area of review, as mentioned, involves extensive subsurface characterization and a full geologic assessment of the injection and confining layers. Data on the location, orientation, and properties of known or suspected faults and fractures that may transect the confining zone are required. Additional information required is a thorough evaluation of the seismic history of the area, including identifying potential risk going forward, and detailed information of all wells which penetrate the injection or confinement zones. Proposed plans cover well construction, injection and monitoring, emergency and remedial response, injection operating plans, and post-injection site care and site closure plans. And finally, the applicant will demonstrate it has sufficient financial assurance to cover CO2 injection and storage activities. After obtaining a Class 6 permit, operators are required to undergo final testing, operational planning, and public notification before receiving authorization to commence injection activities. This crucial phase ensures that all necessary preparations are in place, including comprehensive testing to verify the integrity of the injection well, operational plans to outline the procedures for safe and efficient CO2 injection, and notification to the public regarding the upcoming activities. By completing these final steps, operators demonstrate their commitment to compliance with regulatory standards and readiness to responsibly undertake CO2 storage operations, while also fostering transparency and community engagement. During the injection or operational period of the project, several key activities and considerations come into play to ensure the safe and efficient operation of the well. These include continuous monitoring and reporting of operating data to assess the performance and integrity of the injection well system, regular testing and monitoring of injection parameters, pressure levels, and CO2 plume movement to detect any deviation or potential issues. Periodic reevaluation of operating plans and procedures to ensure alignment with regulatory requirements and address any emerging challenges. And finally, in adherence to regulatory compliance standards and enforcement through inspections to verify operational compliance to permit conditions. Once injection activities cease, there are procedures and regulations for post-injection monitoring and site closure. These are necessary to ensure the safety of USDWs by preventing any potential harm caused by the injection process, injected fluids, formation fluids, or increased pressures. Regulations require post-injector site monitoring for a period of at least 50 years following the cessation of CO2 injection. That's right, you heard me correctly, 50 years. However, this duration can be adjusted based on site-specific conditions, which may warrant either an extension or reduction of the monitoring period if it can be demonstrated the injected CO2 will not endanger USDWs. In terms of long-term site ownership or stewardship, we will initially adopt the EPA requirements, meaning that the operator is liable in perpetuity. This ensures there is always a responsible party. However, we will be evaluating this concept over the next 6 to 12 months and determine if it's the right solution for Colorado. And I would like to mention, I also believe it's being studied as part of the upcoming carbon roadmap. And finally, our rulemaking timeline. I'll start by caveating that these are our proposed dates and deadlines, but they may be subject to change based upon the cumulative impacts rulemaking and other high important items. Our goal is to complete the draft rules by the end of this month to the beginning of July, and then provide the draft rules to the EPA and stakeholders, conduct stakeholder meetings and notice CCS rules in August, and finally have the CCS rulemaking hearing in October. Thank you for your time and attention, and I'll now open it up for questions.
Thank you. If you want to stop the screen share, we'll be able to see everybody a little bit better.
Sounds good.
Great overview. Really appreciate that, Mr. Seeley. I have a couple of quick questions, and I'm sure other commissioners may have some questions as well. Talk to me about the interrelationship between the work we're doing on our CCS rules and how we collaborate with EPA. I guess I had sort of thought that we're going to move forward with our rules, and then once they're done, we're going to then provide them to EPA. But it sounds to me like there is a little collaborative work, like as we're doing our rules. And so if you could provide some perspective about how that works, like we're going to get some EPA insight, and maybe that makes a whole lot of sense because ultimately EPA's got to agree that our rules are as protective as EPA's rules. So how does that process work a little bit further?
Sure, I'll answer that, and then I'll let Lauren Mercer take a stab at it if she wants. But essentially, we're going to work concurrently with the EPA. Typically, the process is that you will submit your rules to the EPA, and they will perform what's called an EPA crosswalk, and essentially going rule for rule, line item per line item, making sure that the state's rules are at least as stringent as the EPA, since that's a requirement for us for primacy. Instead of stage gating the activities in a sequential manner, we're going to, as I mentioned, coordinate and work concurrently through that, and that will occur primarily in July. So hopefully there's not a lot of back and forth and items that or gaps that are identified that would delay our process. But we're doing this in order so that when the rules get, when we conduct the hearing later this year, that we can subsequently move quickly into applying for primacy, which at this point will take a little around a year, potentially over a year. And so I think the sooner we get that application in, then the sooner we can have regulations ourselves. Lauren, do you want to add anything?
You want to add anything, Ms. Mercer?
Sure. Thank you, Mr. Chair, and thank you, Mark. I agree with everything that Mark said, and I'd also add it's going to be a very iterative process, I think, because there's sort of a chicken and egg problem where we have to promulgate and finalize our rules, the ECMC rules, before we can apply for primacy. But we don't want to be in a situation where we go through a whole rulemaking, submit our rules to EPA, and they say, oh, no, you missed something here won't work for us. You have to go back to the drawing board and do a whole new rulemaking. That because of the timing of things, that is always a risk, but our hope is that by involving them early and often in the process, we can minimize that risk and hopefully come out with rules that, from our rulemaking that will be acceptable to EPA.
And just for the 85 people that are listening in, this is a bit unusual for rulemaking at ECMC, where we need to ultimately receive approval from a federal agency that our rules are as protective as their rules in order to be granted primacy for Class 6 wells. The normal course of business for ECMC is that we do our rulemaking and we don't have to receive any approval from a federal agency. So this is a little bit outside the norm. Did I capture that right, Mr. Seeley and Ms. Mercer?
Yes, you did. And the reason for that is because the Safe Drinking Water, the Federal Safe Drinking Water Act is what governs these wells. And they're sort of within the jurisdiction of EPA, unless or until EPA delegates primacy to a state like Colorado. So that's the reason for why we have this unusual situation where we need to get EPA approval.
Great. My other question was around the long-term site stewardship. I know we've received a lot of, sort of specific authority from the legislature and the governor around the work we're doing on CCS. That is an area, the long-term site stewardship, that we've not received kind of initial direction from the legislature. Can you talk to us a little bit in a little more detail about the efforts that ECMC is going to undertake to continue to explore this area so that we can ensure that, and can you also sort of explain sort of the default if we don't have specific legislative declarations around it, then the default is it stays with the operator. And what are the things that we're exploring to determine if that default is really the right place to be, or if potentially there may be a different place to land? I think I kind of understand that other states that have looked at this, that this kind of an area of ongoing investigation. I don't know how to frame that as a question, but it's hopefully you guys got it.
Sure. Would you like me to take that, Mark, or would you like to?
Sure, go ahead, and then I'll follow up anything.
Sure. So yes, so the default is, I'll begin by sort of describing what the options are that we see out there. The default is that the storage operator, so the company that is injecting the CO2, remains liable for, any issues that may arise with CO2 that's injected into a Class 6 well forever. That is currently what we have, because the legislature hasn't directed us to do anything different. That means that, during the injection and the post-injection site care phase, which, as Mr. Seeley said, the default is 50 years for that, ECMC will retain financial assurance, and also the operator will be, liable in court, essentially, if anything goes wrong, as well as liable in a regulatory sense to complete corrective actions as deemed necessary by ECMC. Other states that have pursued primacy have set up a sort of a system of long-term stewardship by the state. And they've done this in a few different ways, but basically The general framework is that after the post-injection site care period, so that 50-year default is over, then ownership of the stored carbon and liability for it and responsible for, taking care of the site transfers to the state. They typically fund that by requiring a fee on every ton of CO2 that's injected during the course of the project. So they've got, a bank of money to cover those obligations. And the rationale for that is that, the goal here is that CO2 will be sequestered forever. And we all know that companies don't necessarily last forever. So if, a company goes bankrupt, is otherwise defunct, who and how are we going to take care of things and make sure there are no issues? So that is an issue that we've heard from many stakeholders, sort of, who there are pros and cons to both approaches. And so ECMC is going to continue studying what they think is the best approach, and working with stakeholders on that. A very important partner or stakeholder is the Colorado Energy Office. And they are working on, as Mark mentioned, the carbon management roadmap right now, which is studying a whole host of issues related to carbon management, including long-term stewardship. So we're working with them and expecting to see some recommendations come out of that report. Mark, is there anything you'd want to add there?
I don't think there's a lot to add. You did a really good job. What I will just reiterate is, the key, one of the key considerations is how long will the operator be around? As Ms. Mercer mentioned, Class 6 or CO2 long-term storage is really in perpetuity. And so we're not just thinking 50 to 100 years, but we're thinking multiple hundreds of years, if not longer. And so it seems like, there are potential risks by having the operator remain kind of as the default liable party. But then you raise into questions of, okay, what type of injection fees or permit fees should be required in order to cover potential future, state stewardship or ownership. And so it's not just a number, it's what should that number be? What is that range and what is that appropriate value? And just requires more time to study and understand what is best for the state.
Thanks, Mr. Seeley. And I'd just add one more thing is that, this is something that is still being discussed, and it is something that will require additional legislation if the state wants to go the route of state stewardship. So we would have to work with the legislature on that.
Okay. I really appreciate the further explanation on those two critical points that I know have been important to stakeholders. So thank you very much for the continued elaboration. Again, a really great report. Commissioners, others with questions? Commissioner Messner?
Thank you, Mr. Chair. Mr. Seeley, really appreciate the presentation. That was really helpful for me to hear. Along the same lines as Chair Robbins, I wonder if you could talk just a little bit about the likelihood of scenarios for transfer of ownership on Class 6 injection wells, and what that looks like from a operator responsibility standpoint, at least contemplated through the first 50 years.
And just to clarify, you're talking about when operations cease or when operations are going, to just general transfer of ownership throughout the life of the project?
Without fully understanding the business concepts behind Class 6 injection wells, are there scenarios where there would be transfer of ownership of these wells from operator to operator? And if so, how does that liability chain follow that transfer?
I think that's a really good question, and I don't have a great answer for you in the fact of it's still early in kind of Class 6 wells. There's just not a lot of real projects with longevity behind to kind of justify and back up whether there's going to be a lot of operator transfers. My inclination is that with the kind of the 45Q tax credits, those hit on the capture facility, not the pipeline or the sequestration well. And so my gut would tell me that there would potentially be more transfer of ownership on the capture side due to the tax credits rather than the sequestration side. I feel like an operator is going to have really strong capabilities in the injection well and storage operations, and I feel like they would maintain that throughout the course of development and afterwards. But again, I think it's a little bit early in projects to ultimately see what that kind of business looks like.
Thank you.
Commissioners, other questions for the panel? All right, I'm seeing no further questions. Mr. Seeley, can you make sure that the PDF PowerPoint is uploaded to that area of our website so that folks have an ability to look at it? It really does give a great overview of all the work that you and our team have been doing, an overview of the legislative direction that we've received. And we look forward to encouraging our stakeholders to be a part of this exciting new dynamic at ECMC.
Will do. Thanks.
All right. With that, we will move to the next matter on our agenda, which is docket number, and there's 4 of them, so bear with, 2211-00316, 2211-00317, 2211-00318, and 2211-00319. These are variance requests by Beeman Oil and Gas, operator number 7125. And the matter is for the commission to consider Beeman's motion to continue the hearing that was originally set for June 12th. Hearings Manager Thomas, were we going to hear from the applicant on this motion, or do you know?
Beeman did not have a presentation. However, Lisa Lawton, representative of Beeman, is available should the commission have questions on the motion to continue.
All right, the motion to continue, just for everyone's sake, is fairly short, so I'll read it. Beeman Oil and Gas is requesting a motion to continue the scheduled hearing set for June 12th, 2024. We would like to do some testing on equipment at other locations to see if it is a possibility to set up these 4 wells the same way. We want to determine if a gas-powered pump jack would work. The small amount of gas produced on each well is questionable for even a small horsepower motor. We are requesting 90 days to complete our tests and data. We will be filing a gas capture plan with any new information and specifications as soon as the outcome is clear. Commissioners, that is the motion before us. Does anyone desire to initiate deliberations on said motion? Commissioner Cross?
Thank you, Mr. Chair. I'll start off saying I'm not sure why they didn't look into this previously. And at least to me, this is a little upsetting that we're facing something that a couple years after mission change, we're just now looking at this possibility. That said, I think if it is a solution, given some of the impacts that could happen to people that rely on the gas production, I think that it's something to consider and look forward to. But at least from my perspective, I think that I'd say I'm kind of at the end of the rope here in terms of letting this go. So I'd be in favor of at least considering putting the hold on this, but definitely a short leash moving forward.
Thanks, Commissioner Cross. Appreciate the industry hat commissioner weighing in to provide us with some guidance on what to do here. Others with deliberative thoughts? Commissioner Messner?
I just have a question. As I couldn't remember, but currently are these shut in or are they operating? Can someone answer that question for me?
Hearings
I
manager.
just elevated Miss Lawton.
Can you hear me? This is Lisa.
Yeah, Ms. Lawton, we can hear you. Did you hear the question?
They have been shut in for 2 years. All 4 of those wells have been shut in for 2 years at this point.
And would they remain shut in while you do this 90 days of evaluation, or do you need to have them operating to be able to undertake whatever it is you're trying to undertake?
I think we're gonna try to work with one of them. It's gonna depend on our equipment availability, to tell you the truth. I think we can maybe get some of them, get it done off of site on the other well we have that's running in the area, the Barbara well that is operating still. It is a gas powered pump jack there, and we're gonna do some tests over there. It has a little bit higher gas flow on that well, so we're gonna try to shut some of that gas in and see if that pump jack will still run at the daily limits of what we have on those other 4 wells. And see, the reason we haven't tried this before is because it's going to be a very costly situation for us to get 4 new pump jacks for those 4 wells when they don't produce a lot of oil and bring in a lot of revenue for us. So we didn't really want to go that route if we didn't have to.
And is echoing Commissioner Cross's wonder, is it the fact that you haven't done this previously, despite the fact that you knew you needed to do something to get into compliance with SB 181 and our rules? Is that just a cost indicia?
It was a cost issue, you know, with those wells producing the small amount of gas per day, you know, and not having very much emissions after the combustion. We were hoping that we would be able to work with you guys and be able to find a solution without having to change all of our equipment on the site, because we do not have any of those pump jacks available. We will have to purchase them and find them somewhere.
All right, Commissioner Messner, I believe your question is answered. Further deliberative thoughts from folks? Commissioner Ackerman?
Thanks, Mr. Chair. I was pondering whether to stay silent on this, but I definitely would prefer more information in the future if we're talking about you know, an actual motion to move forward. I do appreciate that a 90-day time period was requested, and a very brief description of the idea is here. I think what would be helpful in these situations in the future would be to recap the situation, and to even help us understand and remember exactly what's going on with each well in question, and give a more detailed request in the future. I think that would be much more helpful in helping us deliberate.
Yeah, I think those are really good suggestions to this applicant as well as other applicants that may find themselves in the same situation. Commissioner Messner?
Thank you, Mr. Chair. Understanding that the wells in question are currently shut in and that there's an opportunity to test this approach that's being proposed here off-site, I would be okay with the 90-day extension, assuming that the existing wells continue to be shut in and that any testing be done off-site to determine feasibility for applicability to the wells in question here.
Is that a motion?
Yes.
Second.
Have a motion and a second. Further discussion on said motion? Seeing none, all those in favor of the motion signify by saying aye. Aye. Any opposed? All right, Ms. Lawton, the motion to continue is granted for a period of 90 days. We will have this matter redocketed following the 90 days. The 90 days runs from today, not next Wednesday. And Hearings Manager Thomas, we would look to you and staff to forthwith re-bring this back to our attention following expiration of the 90 days at a duly noticed public hearing.
Thank you.
All right, and to all those paying attention, please make sure that you do a better job of articulating the current status of your application in any motion to continue so that the commissioners can reframe their understanding of what is going on. I agree with Commissioner Ackerman in that regard. All right, Let's take up one more item and then we'll take our morning break. We're taking up two matters. This is a little bit unusual. Dockets 231-000-313 and 231-100-343. I would encourage staff to elevate either Ms. Wazelinki or Ms. Jost on behalf of one of the operators and or Mr. Pershala or Anthony Rober, perhaps, who is the attorney for Verdad Resources. All right, Ms. Wazelinki, hi, good to have you with us. And Mr. Pershala, hi, nice to have you with us. I've got some kind of opening comments on these two dockets that I'd like you to listen into. That's why I wanted to elevate you so that we can sort of understand what's going on here and chart a path forward that is going to be appropriate. For everyone's consideration, these are two oil and gas development plans, and they've been submitted for applications for ODDTs that, as I understand it, in part are to develop the same minerals. So we've got two OGDPs that have overlapping development of minerals proposed. And my belief is that it's impossible for both operators to develop these minerals. So the applications in my mind are a little bit in conflict. Do either of the attorneys on either side disagree with that kind of initial statement? Ms. Wazelinki?
Yeah, Chair, and I may have you, sorry, we were sort of, I was making sure Ms. Jost was on the panel. May have you repeat it, but I don't believe, if I'm correct in your position, that both operators, it's impossible for both operators to operate. The filings in this matter do contain a proposed alternative, and on behalf of Kerr-McGee, that would be for Verdad to amend their OGDP. To remove a section or two sections, which would allow both operators to operate.
Right, but I don't believe Verdad has agreed to do that.
That's
Mr. Pershala,
correct.
would you like to have a ever so brief response?
Yeah, I think certainly amendments are a possible outcome and result, but I think your question, Chair Robbins, was that both operators can't develop the same exact section of land simultaneously. And
Okay.
I think that's a fair representation.
All right, and I also been doing this for 5.5 years, but I believe this is the first time I've seen two applications that in part are proposing to develop the same minerals. We had, and I believe it's true, and you guys can correct me, but I've got a few more things to say, that this situation doesn't generally arise because operators have generally sort of worked things out amongst themselves before bringing conflicting applications to the commission. I would encourage both operators, and I have a high degree of respect for both the lawyers on both sides of this. Y'all should go work this out as opposed to bringing a conflicting application to the commission. That said, if the parties can't work this out, the commission will have to act on these applications. Both, in my view, either the commission should approve. So as I see it, I believe what I'm hearing from you is that from the one side, the commission should approve each OGDP and deny the other, or in the alternative, the commission should approve one of the OGTs and amend the other OGDP to remove the disputed minerals. That, I think, is what's kind of before us right now. The second option of carving out the disputed minerals from the operator's application at hearing is not a viable option from my perspective for at least two reasons. First, all the mineral owners in the proposed DSUs have received notice. The notices for both the proposed overlapping DSUs stated that Section 2, that's the conflict one, was a part of the application. No mineral owners have protested either OGDP, but we do not know if that would have been the case if they had received notice of a different DSU and development plan. Second, it is not clear to me that the commission would have sufficient information to support the approval or denial of an OGDP that has mineral development shrunk by an entire section at hearing. Reducing the mineral development area by a section would impact the volume of oil and gas that would be produced and likely change the related emissions, the related truck trips, and all sorts of other things. I would not be comfortable voting on an OGDP where we know that so much of the information that was submitted to us and reviewed by staff is no longer accurate. So if both applications proceed, I believe our only option, assuming that the applications are otherwise approvable, is to approve one and deny the other. I imagine this is a scenario that the operators would like to avoid. And so, as I said, I strongly encourage you guys to work this matter out. However, if both OGDPs move forward for commission approval, neither the act nor the rules expressly address how the commission should choose between two proposed OGDPs to develop some of the same rentals, assuming that both are, again, as I said, approvable, which is an assumption. Therefore, and this is just one commissioner talking, I'll let the other commissioners talk here in a second, I believe it would be appropriate to, and I would like to direct Karen McGee and Verdad to brief this matter on what standard or factors the commission should use to determine which of the competing OGDPs to approve and how to apply that standard to the OGPs at issue. Of course, it is ultimately up to the commission to determine the applicable standard, but I would personally find it helpful to hear from the applicants on this novel issue that you've created in the first instance. With that, again, just one commissioner, but I would request the hearing officer work with the parties on the specifics of this briefing and ensure that it is filed with time for the commission to review this matter before it has come back to us. And I would also move to vacate the hearings today and renotice them once we've heard from the parties on this novel issue. Having said all of that, do any of my I'm going to hear from the lawyers on this here in a sec, but does anybody have any further novel initial thoughts on what's before us? All right, Mr. Prashala, do you want to have a second or two to respond to my ideas about you guys briefing this matter up for us?
Well, I think the rules do provide the standards upon which the commission is would review an OGDP, and as well as the spacing component, because I think there's kind of two elements here. There's the OGDP as it pertains to the surface locations. That's one standard of review, and then there's a separate standard of review with respect to the spacing component, which I think is really the overlapping conflict that we have here as regards to that section 2. So I think there are the standards that are in place under the rules and the act to resolve this, but we're happy to brief the issue if that is the commission's desire.
Okay, thanks. Ms. Weslinski?
Yeah, I think we would agree with Mr. Pershala. I think Kerr-McGee is happy to brief the issue. I agree that I think the standards are set forth in the rules and the act, and we're happy to provide that.
Well, I think it would assist the commission in addressing the novel issue. I think we want to get to the correct result. And I'm not prejudging anything in terms of like what that correct result is at all. So I would, again, then sort of restate it that we'd appreciate getting some briefing on the matter from both sides. Hearings manager Thomas, if you or the relevant hearing officer could work with the parties to develop a briefing schedule, get that done. And then once the briefings are done, then we can have this matter re-noticed for hearing. I don't know that we need any further work from the director or staff on the director's recommendations. Those were pretty straightforward. It's just a matter of the underlying mineral estate and the section 2 thing. Is all that crystal clear as mud, hearings manager Thomas?
Yes, the hearing officer assigned will reach out to the parties following the hearing today.
All right. Anything further from either side?
No, just appreciate that the commission's giving due consideration to this and taking this at a step-by-step approach, and we'll figure out the path forward. Appreciate it.
Okay. Ms. Weslinski, you good?
Likewise, yes, thank you.
Okay. And just to be clear, I agree that we have standards within our rules regarding how to approve an OGDP and the underlying spacing. I think what I'm trying to suggest is that I'm not sure that our standards do a good job, and you guys are all smart lawyers, and so I'm sure you're going to brief this for us in terms of like how to compare two different OGDPs with spacing relevant to the same section. So that's sort of the area of emphasis for the briefing. All right, I'm seeing nodding of heads in the up and down affirmative fashion, so I thank you all for that. I will move to continue both matters to a date uncertain and ask the hearings officer to notice this for agenda following the briefing as we've articulated this morning. Commissioners, does anybody have any further thoughts on that? Commissioner Cross?
Thank you, Mr. Chair. I'll start off saying I'll second your motion and then just say I agree. I think we do have the standards in place. I do think it's important that, should this issue arise again, I think it's also important that we make sure before we're fully considering siting and spacing issues, we understand, as you mentioned, understand how the potential spacing issues could conflict in an overlapping area. And so while the standards are there, I think it's important that we make sure we have that in line before we start citing anything.
Commissioner Messner?
Thank you, Mr. Chair. One of the things that I would like to see in the briefing, while I certainly think that we have standards to approve OGDPs based on protection of public health, safety, welfare, the environment, and wildlife resources, I'd like to hear from the lawyers whether or not they think that there are standards that would allow us to compare two different OGDPs and make a determination that one may be more protective than another, and so therefore could choose one over the other, because I'm not sure that we actually have rules that make that determination. It's certainly possible that two different OGDP applications, even though different, can be approvable based on our rules, but I'm not sure there's rules that are in there that allow us to compare and contrast two different OGDPs. And so I'd be curious to see how you guys will interpret that, but I'm not seeing it in my initial review.
Great clarification, and I believe that segues on the chair's suggestion multiple times that some parties ought to go work this matter out. With that, we have a motion and a second. All those in favor of the motion signify by saying aye.
Aye.
Any opposed? Motion carries. Thanks, guys. We look forward to getting some stellar briefing on this topic.
Thank you.
Thank you.
Let's take our morning break. Let's return in 10 minutes. All right, welcome back. This is the Colorado Energy and Carbon Management Commission. This is our June 5th business agenda. We will return from break and we're going to take up two additional matters this morning. First is an oil and gas development plan for Karis Piance LLC, docket 231100344. This is called the RNPU Fed H28-197 OGDP. And I believe that Ms. Wazelinski is the attorney for the applicant. Good to have you with us again.
Thank you. Good morning.
Do you want to bring your witnesses to the table and then we can get them sworn in?
Yes, we have all of our Karis witnesses on the hearing. If you could all please go on camera and be ready to unmute.
AG Mercer, the swearing in is yours.
Thank you, Mr. Chair. Good morning to the members of the panel. I will go one at a time and ask you each to raise your right hand, state your name, and that you swear to tell the truth. I'll begin with Ms. Hill.
Holly Hill, I swear to tell the truth.
Thank you. Mr. Yancey?
Alex Yancey, I swear to tell the truth.
Thank you. Ms. Oda?
Holly Oda, I swear to tell the truth.
Thank you. Ms. Ryder?
Lindsay Ryder, I swear to tell the truth.
Thank you. And finally, Mr. Dismukes.
Chair Dismukes, I swear to tell the truth.
Thank you to the members of the panel.
All right, Ms. Wazelinski, the video panel is yours.
Thank you. We'll put a PowerPoint up and then I will get started.
Let me know if that's the right screen, Kelsey.
We can't see it. Thank you.
Can you see it now?
Not yet, no. There we go. We can see your screen, but not the PowerPoint.
Okay. That.
It just stopped sharing.
Oh, yep. It just gave me a notification that it disconnected.
There we go.
There you go.
Perfect.
Great. Thank you very much. Well, good morning again, commissioners. My name is Kelsey Wazelinski with Jost Energy Law and with Jamie Jost. We represent Karis Piance LLC in the RNPU Fed H28-197 OGDP before you today in docket 2311-00344. We would like to thank Rio Blanco County for its support of the OGDP, ECMC staff, and the director for their efforts on this OGDP. And we also want to acknowledge the revised director recommendation issued for this OGDP and would like to thank the staff for their work on this. Next slide. There you go. So in addition to myself, there are 5 representatives from Karis at the hearing today who will be presenting or available for questions after our presentation today. And these representatives are listed here. Next slide. I'll take just a few minutes to summarize the RNPU Fed H28-197 OGDP and requested relief before I turn it over to Karis. This OGDP requests that the Commission establish an approximate 484-acre OGDP for the development of 21 new directional wells in the Williams Fork and Isles formations in Rio Blanco County. The OGDP also requests that the Commission approve one Form 2A for the RNPU Fed H28-197 pad for the development of 21 new directional wells. The entirety of the mineral development area is located within the revised North Parachute Federal Unit and the Freedom Federal Unit. Karis will describe the status of the 21 federal APDs in the presentation today. The proposed RNPU Fed H28-197 location triggers 1 Rule 304 ALA criteria. It is within elk and mule deer migration and winter concentration areas and mule deer severe winter range. Karis will describe its consultations with CPW, alternative location analysis, and committed BMPs to protect these habitats in the presentation today. The OGDP contains 2 variance requests. The first is Rule 406E4 to allow for 18 months instead of 6 months to drill the wells following setting of conductors. And the second is for Rule 1003B to delay interim reclamation to commence within 18 months of setting the last conductor for the 21 wells. And these variance requests are due to federal and CPW wildlife timing restrictions. Karis will also describe its proposed reclamation bonding in the presentation today. Karis does agree to the revised COAs contained in the revised director recommendation for this OGDP. And finally, Karis has complied with all notice requirements for the OGDP, no formal petitions were filed, and no public comments were received on the Form 2A. And with that, I will turn it over to Alex Yancey, the asset manager for Karis, to continue the presentation.
Good morning, commissioners. I'm Alex Yancey, Karis's asset manager. Thank you for the opportunity to present this OGDP to you today. The RNPU H28 pad is a very remote pad. As you can see from the map, it's approximately 37 miles north of I-70 and the town of Parachute, and over 200 miles west of Denver. The pad is located in Section 28 of 1 South 97 West and is part of 2 established federal units, the revised North Piance and Federal Freedom Unit, for a combined total of approximately 30,000 acres. This OGDP will cover our plans to construct an access road, pad, and drill and complete 21 directional natural gas wells. Myself and the rest of the Karis team will demonstrate our development approach of avoidance, minimization, and mitigation. Next slide. As mentioned, the development will be within 2 federal units and is subject to the PIONS wide spacing order from 2018, which defined downhole well density and unit setbacks. The map on the left-hand side illustrates in plan view how the wells will be drilled from a single pad, with bottom holes extending into both the Freedom unit and the revised North PIONS unit. We are being very mindful of permit expirations and waiting to submit the federal APDs. However, we have completed many collaborative meetings, and we'll see that in our upcoming timeline and consultation slide, but have made significant efforts with most of the work already completed. Next slide, please. Now moving on to the specifics of the H28 pad. The yellow highlighted polygon is the future H28 location. The closest white polygon to the north and east is the A27 Central Delivery Point, or CDP. You'll note that the H28 access road utilizes the A27 access road from County Road 5. This will be the second pad that we will develop that produces into the A27 CDP, with the B27 development pad on the eastern edge of the map, also in white. There are multiple purposes of the CDP, including separating fluids and natural gas and serving as a remote frac pad. With using a CDP, we can minimize the amount of surface disturbance and wildlife impact. Additionally, we will pipe recycled water for frac operations to the pad, and the produced water will also be piped off location. And now I'll turn it over to Holly Hill, our regulatory consultant.
Thank you, Alex. I'm Holly Hill with Fielding Hill, and I'm a regulatory consultant for CARIS. As Kelsey mentioned, the RMPU fed H28 197 well pad does trigger the HPH, high priority habitat, for the ALA requirement. Again, this is in elk and mule deer migration and winter concentration, as well as mule deer severe winter range. Next slide, please. The ALA considerations for the RMPU fed H28 197 are depicted below. Alternative locations 1 and 2, which were called PCU G21 197 and PCU O21 197, had some pros by being in close proximity to existing CARIS infrastructure. There would have been the ability to utilize an existing 2-track road for access. However, these well pads were situated in an ECMC mapped wetlands and native aquatic species conservation waters, and was situated too close for comfort to the Piance Creek, presuming there was a shallow water table for those 2 locations. Alternative location number 3, the PCU L28 197. Again, the pros were that this had close proximity to existing CARIS infrastructure. It was unfortunately situated again in ECMC mapped high priority habitat. And more concerningly, the access road that would have been required to access this location would have been 2 times longer than the proposed access road. And now I'll hand it back over to Alex.
Thanks, Holly. Now I'll give a brief update on our access road construction. We presented this to the Commission last September, and since then, approximately 80% of the road has been completed prior to entering big game wildlife stipulations starting December 1st. Big game wildlife stips ended April 30th and work has once again resumed. We estimate this road will be completed by the end of this month. Next slide, please. Now I'd like to touch on a few operational items. First, we've been dialoguing with the local utility, the White River Electric Association, about the optionality to extend line power to location. Those conversations have been very positive, and we've made a financial commitment to White River so that they can pursue the required agency approvals. Assuming the approvals can be obtained, we will be using non-emitting electric motors for our drilling operations. For the frac operations, we do not use proppant, which dramatically reduces truck traffic. We estimate that this saves over 5,700 truck trips. Additionally, we use produced water, which we recycle and pipe to location. This saves approximately 1,500 truck trips per well, or 31,500 trips for the entire pad. We pump produced water off location, and in the first 90 days, we estimate that this saves over 23,500 truck trips for the pad. In total, our operations have eliminated an estimated 60,200 truck trips. For the production operations, we will be using non-emitting pneumatic devices, and our production facility will be electrified. Finally, we'll call your attention to the draft operational schedule in which we would prepare the pad in 2025, and drill and complete operations would start in 2026. To summarize, our operational plans work hard on avoidance and minimization by number 1, no construction activities during big game winter stipulations. Number 2, pad and road co-development that minimizes surface disturbance. And number 3, piping all water and using recycled water for frac operations, which minimizes any freshwater requirements. Thank you, and now I'll turn it back to Holly.
Thanks, Alex. As mentioned before, the RNPU Fed H28-197 is situated roughly 37 miles north of the city of Rifle. It is situated in Rio Blanco County on federal rangeland in the southeast northeast of Section 28, Township 1 South, Range 97 West. As you are well aware, Rio Blanco does not have oil and gas siting regulations, meaning that they cannot dictate the placement of infrastructure for oil and gas locations. Rio Blanco does have a oil and gas well pad special use building permit, which requires a per well fee, which Caris will permit closer to the time of development. The RMPU H28-197 well pad proposes to develop federal minerals from federal surface. And this well pad is concurrently being permitted with the White River Field Office BLM. This location is pending APD BLM approval. However, this location has been vetted by the BLM. In fact, I was present at the onsite in September of 2022, where BLM representatives were available, and we discussed this location thoroughly. So we do not expect any NEPA objectives that we haven't already vetted in the cumulative impact plans or the wildlife management plans. Additionally, Caris endeavors quarterly meetings with the BLM, and this location has been on those updates with the BLM. They are aware of it and are aware that Caris will be seeking permits shortly. Next slide. This is a brief snapshot of all of the consultation efforts that have been underway. These locations were, Caris started looking at these locations in September of 2021, and very thorough overview and thought went into selecting the locations, and several pre-consultation meetings have occurred with CPW, ECMC, and BLM. And now I'll hand it over to Jerry Dismukes.
Thanks, Holly, and thanks, Commissioner. Again, I'm the Air Compliance Manager for Caris. I oversee a lot of all of our continuous monitoring operations out in the field. So as for this particular facility, and as well as for numerous facilities, as of May of 2021, Air Quality Control Commission under Reg 7 requires continuous monitoring at all new pads from 10 days prior to spud through 6 months of final early production. So we're doing that currently on approximately 10 locations. We've been doing this for almost 3 years now at all of our new pads. What this allows us to do basically is we have to submit this data. Well, we analyze it at the end of each month and submit the data to CDPHE, which is also made publicly available. And what we do with that data basically is we submit a plan to the Colorado Department of Health, and they approve it after some back and forth typically. Now we're pretty lined out and pretty consistent, but we have to establish alert levels on our facilities. So we'll put out 3 or 4, depending on the location, canary monitors currently. And we've been monitoring those for VOC. Going forward, we're switching over to monitoring for methane as a surrogate for total VOC. And we can establish alarm levels that allow us to be alerted in real time as to when and if we do see emissions issues on our locations. So in the slide down below, you'll see kind of like what we see or what I see on a daily basis. I can see our real-time total VOC or methane concentrations at our monitors on our pad. And we can get, on occasion, we get alerts as to if something unusual is going on. And then we have a requirement to respond to that event, either by sending out one of our LDAR teams to go look at it with an OGI camera, or if we already know the issue, we can just annotate what that issue is and then submit this data to the state. For this particular pad, we're planning to probably monitor for methane, not total VOC, again from spud, actually 10 days prior to spud. through the first 2 years of operation at a minimum. For the most part, we have been continuing to monitor all of our locations well past the requirement by CDPHE, just so we can keep eyes and ears on our locations and be aware of what's going on from an emission standpoint. Next slide, please. And I think I turn this back over to Lindsay.
Good morning. Again, my name is Lindsay Ryder, and I'm the Director of EHS for CARES. I'm going to cover the wildlife mitigation efforts completed for the H28. At CARES, we follow the wildlife hierarchy by first avoiding, then minimizing, and finally mitigating our potential impacts to wildlife. On the H28, we worked with BLM and CPW to avoid other critical resources during the site selection, as noted in the ALA. We also plan to construct the location outside of the big game winter range timing limitation, which runs from December 1st to April 30th. By scheduling construction operations outside of the winter timing limitation, stress on big game during winter months will be avoided. I'll discuss in more detail the specific wildlife BMPs that will be employed at this location to minimize impacts on the following slide. We worked with CPW to develop the fee amount for compensatory mitigation, and we are planning to remit $101,568 for this project. Next slide, please. We've listed several BMPs for the different phases of this project, and I'm only going to note a few in each category. For construction and reclamation, as mentioned, we're going to construct outside of the big game winter timing limitation. CARES has worked with BLM and CPW on an approved seed mix for reclamation, and CARES will provide training opportunities for our vendors on stormwater, topsoil conservation, and reclamation techniques throughout the year. For development, CARES will only operate during daylight hours while completing stages 1 and 2 to minimize sound during the night. CIMOPs will be employed on this location, and as you've heard, we'll be utilizing recycled water to complete our wells. We will also employ the continuous air monitoring, as Jerry just mentioned. For production, we'll use our remote well control and monitoring systems, also known as SCADA, to reduce truck traffic, and we'll use solar panels as an alternative energy source for on-location production equipment. I'll turn it now back over to Holly.
Thank you, Lindsay. As Kelsey mentioned, CARES is seeking a Rule 502B variance to Rule 406E4 to allow for 18 months instead of 6 months to drill the wells following the setting of conductors. And similarly, a Rule 502B variance to Rule 1003B to delay interim reclamation to commence within 18 months of setting the last conductor for those 21 wells. Again, this variance is required due to federal and CPW wildlife timing restrictions. I'd like to draw your attention to the schedule over here on the right, which is just a different depiction of what Alex presented before. Again, constructing outside of that big game winter timing stipulation. Typically, construction occurs in the fall when the soil is the most suitable for those activities. Then CARES would come back and reoccupy the pad around July 1st of 2026 to conduct CIMOPs for all 21 wells. And then interim reclamation would occur the following year in July to October. As such, CARES has agreed to provide a bond in the amount of $573,625 to cover the complete cost for reclamations at this location, and this was provided in CARES's variance application. Next slide.
Thank you, Holly. So to summarize the RNPU Fed H28-197 OGDP and request for approval, I'll note the following highlights. The commitments presented by CARES today and the BMPs on the Form 2A protect and minimize adverse impacts to public health, safety, welfare, the environment, and wildlife resources. The only ALA criteria triggered is for HPH, and CARES has collaborated with CPW and the BLM in developing wildlife protections, compensatory mitigation, and the wildlife mitigation plan. The OGDP minimizes surface disturbance by using the approved A27 CDP pad for remote hydraulic fracturing operations. CARES will utilize existing pipeline infrastructure to avoid new right-of-way disturbance. All gas and produced water will be piped off location to minimize traffic impacts. CARES will utilize over 95% recycled water for completions, And finally, as we have stated, Karis accepts all COAs listed in the revised director recommendation. And so with that, we respectfully request approval of the OGDP and associated Form 2A. And this does conclude our presentation. So we'll take the PowerPoint down and our team is open for questions.
Great. And you respectfully move for approval of the OGDP. And I assume that also would include move for approval of the 2 requested variances.
Oh, correct. Yes.
Okay. Great. Commissioners, the panel is open for questions. Commissioner Cross or Commissioner Ackerman?
Thanks, Mr. Chair. I appreciate the presentation and the materials that were provided. I do have just a couple of questions, and we focused on construction taking place outside of the big game timing limitations. And I think it was slide 10. We don't need to pull that back up, but demonstrated a bit of potential drilling overlap into the big game timing stipulations. I don't know, Mr. Yancey, if you're the correct one to respond to this, but perhaps you can talk a little bit about the drilling plan, the duration that you believe, and what would cause it to potentially leak into the winter timing stipulations. And if so, what the process for the operator would be to work for approval of that.
Alex, if I may just pipe in, sorry, and then hand it over to you. So I totally glossed over that on the slide, Commissioner Ackerman, so thank you for bringing that up. Karis will likely seek a continuous exception for drilling and completions, which is contemplated in the White River Field Office BLM Resource Management Plan that was amended in 2015. Karis will request that exception closer to the time of those operations so that BLM can assess that request in real time to consider any impacts to the species. And once Karis gains that approval from BLM, if they approve it, they will provide that to CPW for their review and approval. And should CPW also agree, Karis will provide both of those approvals to ECMC via Form 4. And Alex, Lindsay, feel free to leave in anything I left out.
I have nothing further. Thank you, Holly.
Yeah, you stated it accurately.
Thank you, Ms. Hill. I appreciate that. And the next question is probably to you as well. It's related. Do you have an idea of what the potential BLM approval schedule is at this point? It looks like you're nearing completion of that process.
Yes, I believe Karis plans to submit those APDs in the next few weeks or month. They're just trying to submit those closer to the time of when they need that approval because BLM's APD timelines are now 3 years with no extensions. So Karis is just trying to thoughtfully stay within those permit approval timelines.
Thank you. And when you talked about, back to the first question, when you talked about a filing for an open exception, I think as you put it, or whatever terminology you used, can you detail a little bit more what the potential drilling schedule might be and how far that might leak into the winter timing stipulations, which are set to begin December 1?
Yeah, so it looks like drilling and completions would roughly take about a year. So those will definitely dip into the winter timing stipulation. But Karis is conducting SIMOPS, which significantly reduces the time that is spent on that pad and takes advantage of that continuous approval that BLM or CPW would likely grant for continuous development. And that one occupation is less impactful to the species nearby. In fact, CPW and BLM prefer that operators do one occupation versus several to minimize the impacts to the species in the area. And Alex, Lindsay, again, feel free to fill in.
Yeah, I'm just going to touch on that a little bit. So we designed the pads so that the wellheads are on 9-foot centers and they're in a continuous line. And as the rig moves down on the pad and drill these wells, that then we can come in and do our frac operations and at one end of the pad while we're finishing the drilling operations at the other end. And so that way it really helps compress that schedule for our drilling and frac operations. And then we complete everything and then move off. And so then there's no more activity that's happening after that. So.
Thank you. And I can't remember if that was, and I don't mean to interrupt if Ms. Ryder had something to add. Thank you. And I can't remember if it was 2026 or 2027 that you commenced drilling. I think it was 26. Is that correct?
26, yes.
26. And so just to be clear, does that mean if you file for an exception with the duration of time and the continuous drilling and fracking operation, does that essentially mean that the winter of 2026 would see continuous drilling on this pad all the way through?
From the proposed schedule that we have right now, we would start it in second, third quarter of 2026 for drilling operations, and then frac operations will continue on through winter into early 2027.
Thank you. No further questions, Mr. Chair.
Additional commissioners with questions, Commissioner Messner?
Thank you, Mr. Chair. Following up a couple of questions on Commissioner Ackerman's questions. And I'm trying to understand what's being proposed here, because there's some things that seem to be in conflict, and I'm just trying to understand them. So there's a variance request out there that's part of this that contemplates an extended timeline in order to meet timing stipulations. But yet you're indicating that you're going to ask for an exception so that you can continuously drill through those timing stipulations. So why the need for a variance?
So the variance requests really revolve around conducting that interim reclamation, which per the rules on rangeland, operators basically have to commence interim reclamation within 6 months of the last activity. So, or based on 6 months after setting the last conductor, if we're looking at Rule 406E4. So this builds in the timeline allowed, contemplating when we'd actually begin construction, subsequently the drilling and completions, and then interim reclamation. Because it's typically frowned upon to commence interim reclamation during big game timing stipulations, Caris is seeking this exception just to make sure we're not in violation of any of those 6-month timelines to commence interim reclamation on rangeland.
Okay, so the variances are specific to reclamation and have nothing to do with drilling and completions.
Correct.
But yeah, just to add some more color on that too, the conductors that is set at the time of when we build the pad and the road. So that's considered construction activity. And that's why it's done in that fall season outside of big game stips. So that's not considered part of the DNC operations, which we have approval for.
Okay. And the pad that is being contemplated for the remote frac and production, that is also in all 3 of these high priority habitats, is it not?
Correct. That's correct. And it was reviewed at a previous OGDP application. I believe it was the RNPU phase 1 OGDP for Caris. So that PCU A27197 location is going to be utilized for 3 locations as the remote frac, and it also will serve as the central delivery point. Again, that helps to reduce surface impacts in the area, and by utilizing the remote frac at a secondary location, continuous operations can occur.
And I wonder if someone could talk a little bit about, what that looks like with SIMOPS being done on 2 different pads in proximity to each other in 3 high priority habitats. And while there was no traffic plan that was submitted as part of this, if I pull information off of the Form 2B, contemplating 20 truck trips a day for drilling, 12 truck trips a day for completions, and these activities happening concurrently through the winter timing stips, how does that impact wildlife cumulatively as you look at these 2 different operations with the amount of truck traffic that's being contemplated on 2 different pads and the activities that are occurring? How are we avoiding, minimizing, and mitigating impacts in that situation?
I would like to take a stab at that one. So our previous experience working with CPW and BLM with the year-round drilling and completion exception requests, The reasoning behind it is that when we can complete that intense activity, drilling and completions in a single occupation, we believe that the impacts are less on the wildlife in the area. It'll be elk and mule deer in this case. It limits the time we're on that location. It allows us to not bring in a rig a second time, which would be increased truck traffic for that second occupation. And then it also allows us to get the location interim reclaimed quicker if we can do it in a single occupation. So we view the impacts of a single occupation that they would be far less than multiple occupations to do completions and drilling at different times to avoid the one winter TL.
And if I may, the activity that's going to occur at that CDP, the A27-197, the 3 pads that it would support has been pre-vetted with both BLM and CPW. And so I believe the compensatory mitigation fees for all of that activity at the A27 were included with that RMPU Phase 1 OGDP.
That's accurate.
Thanks for that. I will note that it wasn't clear to me in CPW's consultation whether there was a full understanding of what was being proposed, nor in the consultation summary that was provided by Karis. And so I note that there's no representation from CPW today for me to ask questions to, but I do wonder, because there are different CPW consultations that indicate that multiple occupations are actually better in high priority habitats. I think what you're indicating is that one occupation is better. To me, that's in conflict. And so it's confusing to me as to what's the appropriate avoidance measures here in this particular situation. And I'll certainly lean on Commissioner Ackerman for his thoughts on that as a wildlife expert. But the amount of truck trips that are associated in combination with the activity on pads through specific timing stipulations. And my understanding is from previous consultations and applications is that one season of impact is enough to permanently shift some of these winter concentration areas and migratory corridors. And so I have some heartburn here, but I have to lean on CPW as the expert. It's just not clear to me that they got the full picture of what was being proposed here or not.
If I may, Commissioner Messner, I'm pretty confident CPW is very aware of the plans here, and perhaps we could have done a better job explaining all of the interactions with the PCU A27-197 CDP. I believe sometimes why you hear it's better for reoccupation is dependent on the species. So I think if there's sage grouse involved, CPW and BLM are a little more sensitive on operating during those time periods, and it just sort of depends on the area and those species. But specifically for the big game area, BLM does have mechanisms to assess that. And again, we would get their approval first and then CPW's as well.
Others with questions for the panel? Do we want to turn to deliberations? Commissioner Ackerman?
Thank you, Mr. Chair, and I appreciate Commissioner Messner's further exploration of the issue. I would just note briefly that in the future, it would be helpful to have very clear statements regarding the drilling schedule that would help us understand that might be taking place during the timing stipulations without us having to dig for it. It was included in the application materials and saw it in the presentation as well, but just wanted to make that editorial note. So on one hand, this application does clearly suggest drilling and fracking operations during winter timing stipulations within high priority habitat 3 times over, as noted by Commissioner Messner. And I do want to note that this kind of activity is contemplated, as was noted, I think, by Ms. Hill, under specific conditions in the BLM RMP. It might have been Ms. Ryder. Apologize if I got that wrong. And those RMPs go through significant public input, governmental review, including CPW's hand as well. And so, as Commissioner Messner noted, I do give some deference to CPW on their wildlife expertise and the consultation that's taken place here. And I do believe that they also understand that and consulted that in this scenario that one application or one occupation, excuse me, would be preferable over multiple occupations. Now that said, they didn't really opine over is one occupation or multiple occupations better than no occupations, right? They did that under the assumption that this would move forward under one of those two scenarios. You know, on the other hand, this application, what it's suggesting, in my opinion, does so in a very reasonable fashion with various BMPs and under the significant guidance of not just CPW, but BLM. And that would include a full BLM NEPA process as well. I do believe that in most cases that the operator here is avoiding sensitive habitat to the extent practicable. The exception to the winter timelines, as we discussed, is subject to significant further analysis and approval processes by BLM, by CPW, and through ECMC, although that would not be back before the commission, as I understand it. There are also, as was suggested, mitigative payments made to address these issues where they could not be avoided. To the tune of just over $100,000, which would, in my understanding, be subject to change if there is significant discussion and approval of potential timing limitation modifications and activity within that time frame, which would be further calculated at that point. I appreciate the three-phase gathering that's become the standard for Caris and that there aren't any RBUs within a mile. The use of produced recycled water to a great extent and the piping of completion fluids. And I am in support of the variance that avoids reclamation during sensitive time periods and appreciate the $500,000 in additional bonding associated with the timing variance. And this is a great example of one of these complex wildlife issues that have been in existence for quite some time on the Western Slope. I want to note that pre-mission change rulemaking, some of these things may have been implemented, some of these things may not have been implemented, some of them may have been implemented in part. This is a good testament to that we're having this discussion to the mission change rules and the protections for wildlife that have been set forth in the mission change rules. I believe that the application as proposed is within the context of those rules and offers protection to wildlife that is acceptable. CPW was involved in the ALA and also states that the operator specifically has effectively consulted with them to implement the full mitigation hierarchy, and CPW has noted that they do not have any unresolved issues or objections. So with that, Mr. Chair, I would be in support of this application. I would be interested in understanding, as I understand this won't come back before the commission, I would be interested maybe in the future of some kind of brief that would help us understand if we do make an affirmative decision today, what a potential reworking of the timeline stipulations actually ends up looking like on the back end. I think that could be helpful to us at some point for future applications. That's all I have to kick things off. Thanks.
Appreciate you kicking us off there, Commissioner Ackerman. This application deserved your attention from your expertise in your seat. I agree with all the things you said and appreciate those points. Commissioner Messner.
Thank you, Mr. Chair, and thank you, Commissioner Ackerman, for providing clear thoughts on that. That always is helpful for me as I'm deliberating on an application. I do want to just start off by saying that there's a lot of things in this application that I think are really good, and I really appreciate the work that was done by Caris on this application. I think that, you know, the consideration of, you know, electrical power to site, solar utilization, produced water, recycling, three-phase takeaway, remote frac SIMOPS. I mean, there's lots of good things that are going on here, and I really do appreciate that. And ultimately, in this particular situation, I will defer to our wildlife experts at CPW to make a determination as to the protection of wildlife. It's still a little confusing to me, the different opinions of different wildlife experts within CPW and different high priority habitats. And so certainly I'll continue to lean on them for their expertise. But just on a side note, I think it could be helpful to understand or to get a presentation from CPW to better understand scenarios where single occupation is better versus multiple occupations, because it still is a little bit of a head scratcher for me in reviewing applications. But nonetheless, I do acknowledge that there's a NEPA process that's been done on this, that BLM will continue to review a potential exception to this. It's not clear to me what the backup plan is should the BLM not choose to approve an exception. And how that ties into the timelines associated with this application. But I know that CPW is intimately involved with that BLM exception process. And so I again will defer to their expertise. So as Commissioner Ackerman indicated, understanding the consultations that are in place, this is approvable from my standpoint.
Commissioner Cross.
Thank you, Mr. Chair, and I'll just be brief, given that I think most of my talking points have been covered by other commissioners already. I do think that there are a lot of great things in this application, as Commissioner Messner listed. There's a lot of benefits and great efforts, including the electricity. So I'll just say that I am also in favor of this, and I would move for approval of the application with the conditions of approval proposed.
And thank you for that. I believe, let's do a little clarifying on the motion. There are 4 revised conditions of approval in the director's recommendation, I believe. And I believe that any motion for approval should also include the 2 variances. AG Mercer, do I have that right?
Yes, Mr. Chair, that's correct. Any motion should include the conditions of approval from the revised director's recommendation, as well as the 2 variance requests.
Friendly proposed amendment to the motion, Commissioner Cross?
Accepted.
All right. I will second that revised motion. Is there further discussion on the motion from commissioners? Seeing none, all those in favor of the motion signify by saying aye. Aye.
Aye.
Any opposed? The motion carries. Thank you very much to the panel. Thank you to staff. Thank you to BLM and CPW for the work on this proposed application.
Thank you.
Thank you, commissioners.
All right, let's take 5 and return in 5 minutes for our last Elbert County Mud Drilling Company OGDP. Welcome back, folks. We now will take up our last business agenda matter for our June 5th Energy and Carbon Management Commission hearing. It is docket number 230200054, an oil and gas development plan. The applicant is Mull Drilling Company, and the attorney is Christopher McGowan. Good afternoon, or good morning.
Good morning, commissioners. It is morning there, I assume. I'm in a different country, so but anyway, good morning to you as well, Mr. Chair and fellow commissioners. Are we good to go? Do you just want to jump in?
Let's bring up your witness or witnesses and have them sworn in first.
Yes, sir, Mr. Chair.
Is it just Miss Donahue?
Ms. Donahue will be doing the presentations, and then we have some folks from Mull Drilling that are available for questions. So Ms. Donahue will be the only other one presenting at the time, and then Mull Drilling is there for questions if anything comes up with you and your fellow commissioners, sir.
AG Mercer, figure out what you want to do with the swearing ins.
Thank you, Mr. Chair. I think it would be best to go ahead and get everyone sworn in now. So I'll start with Ms. Donahue, and then I'll move to the conference room. And if folks at at mud drilling could just go around the table one at a time, and each raise your right hand, state your name, and that you swear to tell the truth. We'll begin with Ms. Donahue.
Morning, my name is Jessica Donahue, and I swear to tell the truth.
Thank you. And now to the conference table. We can't hear you if someone's speaking.
How about now?
Perfect.
Yes.
Hi, my name's Preston Dahl. I swear to tell the truth.
Thank you.
I am Dustin Dammy, and I swear to tell the truth.
Hi, I'm Risa O'Brien. I swear to tell the truth.
Hi, I'm Jennifer Mole. I swear to tell the truth.
Mike Macelia, I swear to tell the truth.
Thank you all. You are now sworn in.
All right, Mr. McGowan, you are up.
Thank you, Mr. Chair and fellow commissioners. As indicated before, my name is Chris McGowan, and I am counsel for Mole Drilling. I just want to correct the name; it's Mole Drilling. The applicant in docket number 2302000054. We are here today on the Williams number 124 oil and gas development plan. We are before you today to ask for approval of the Williams OGDP and associated 320-acre drilling and spacing unit. Mole, the applicant, is a Kansas corporation who is a registered operator in good standing with the commission. Mole is seeking approval of an approximate 320-acre OGDP and associated DSU for the development and production of one total vertical well to be developed from one well location, oil and gas location, in the south half of Section 24, Township 13 South, Range 57 West, the 6 p.m. The surface location of the well will be in the southeast-southwest quarter of Section 24, with the nearby public crossroads being County Road 14 and County Road 197. With this application, Mole provided the commission of an assignment of oil and gas leasehold interest in the mineral tract to be developed within the application lands in accordance with ECMC Rule 303A1. As part of the application, Mole also submitted a Form 2A for the development of one new vertical well within the application lands from the proposed Williams 124 oil and gas location pursuant to Rule 303A2 and Rule 304, document numbered 402977152. Mole also submitted a Form 2B cumulative impact data identification pursuant to Rule 303A5, document number 403303896, and a Form 2C OGDP certification pursuant to Rule 303A7, document number 403303898. Albert County is the relevant local government, and pursuant to Rule 302E, Mole notified Albert County as the relevant local government that it planned to submit the Williams 124 application no less than 30 days prior to submitting the OGDP application. There are no proximate local governments within 2,000 feet of the working pad service for the Williams 124 location and OGDP, and the 30-day pre-notice complied with the procedural and substantive requirements of Rules 303E2 and 3. With the application, Mole also submitted a drilling and spacing unit application for a 320-acre drilling and spacing unit, along with its required Rule 505 testimony. The testimony submitted supports approval of the OGDP and associated 300-acre DSU, and that the OGDP and DSU are in compliance with statutory and commission rules and regulations. Also, that the 320-acre drilling and spacing unit and OGDP will prevent waste, protect correlative rights, maximize the efficient economic production of the Morrow Sandstone Formation, and will result in a development that will protect and minimize adverse impacts to the public health, safety, and welfare of the environment and wildlife resources, and will protect against the adverse environmental impacts on any air, water, soil, biological resources in compliance with CRS 3460-106. The application and testimony further support that the DSU complies with ECMC Rule 401, and there are no current existing applicable ECMC orders covering the application lands. Mole provided copies of the application and the notice of hearing to each interested party as required by Rule 504A, Rule 504B1, 504B2, 504B5, and 303E. Mole further provided copies of the completeness determination to all interested parties, and when it was made by the director of the Williams OGDP as provided for in Rule 303E. I will now turn the presentation over to my colleague, Ms. Jessica Donahue of Arter Environmental.
Morning, commissioners. So this morning we will go over a company introduction for you for MOL, and then we'll go over the project details itself. For the record, my name is Jessica Donahue with Ardor Environmental, and I'm here today presenting on behalf of MOL Drilling Company. MOL is a Kansas-based operator that has been actively operating oil and gas wells in Colorado for over 50 years. Their focus has been on exploration and production activities in eastern Colorado, which was instrumental in the establishment of 7 different producing fields throughout Cheyenne and Lincoln counties. The company was originally founded in 1954 by J.A. Mull Jr. They have active operations in multiple states and continue to operate under the 3rd generation of Mull family leadership. Under the 700 rules, Mull is an option 2 operator with an improved Form 3. Mull is in full compliance with the ECMC's financial assurance requirements. The Williams OGDP has proposed to drill a single well from one oil and gas location located approximately 25 miles south of Lyman in the southeast southwest of Section 24, Township 13 South, Range 57 West. As a part of the application, Mull is also proposing a 320-acre drilling and spacing unit, which includes the proposed surface location. The proposed location and associated DSU is located fully within Elbert County. There are no proximate local governments for this location. The nearest public crossroads are County Road 14 and County Road 197. And as you can kind of see from the aerial here, the Williams location is in a rural agricultural area. The Williams OGDP proposes 1 vertical oil well. The location has an overall EnviroScreen score of 20.871. There are no building units, residential building units, schools, or high occupancy building units as defined in the Commission's rules within 1 mile of the proposed location. On August 24th, 2023, the OGDP was submitted to ECMC. On March 19th, 2024, Mull received its completeness determination from staff. The OGDP then underwent its 30-day public comment period. No comments were received. No petitions have been filed on this project. On May 16th, 2024, staff issued the director's recommendation for approval. The Williams 124 is a single vertical well proposed on a new location situated in rangeland. This location is proposed to have an initial oil and gas location disturbance of 7.13 acres. After interim reclamation, the final proposed Williams location will be 2.3 acres. This location is not within high priority habitat. Additionally, it does not meet any other Rule 304B2B criteria for an alternative location analysis. As mentioned previously, this location is located within Elbert County. As per Elbert County, major oil and gas facilities are allowed as special use by review in all zone districts and subject to building permit review. Minor oil and gas facilities are allowed as use by right in all zone districts, subject to building permit review. Elbert County oil and gas land use regulations can be found in Article 5, Uses and Supplemental Standards, Supplemental Standards number 21, Oil and Gas Facilities. Oil and gas companies intending to drill in Elbert County will need to acquire the necessary permits and permissions from the ECMC before submitting an application at the county level. Mull conducted a pre-application meeting with Elbert County on June 16, 2022. During this meeting, it was determined the proposed Williams OGDP would qualify as a minor oil and gas facility under Elbert County's current zoning regulations. Additionally, it was agreed that Mull could submit their permit prior to ECMC final approval. Mull has submitted its application to Elbert County and has been in regular communication with Elbert County staff. Elbert County staff communicated to the operator that Elbert County regulations would require the ECMC approval prior to Elbert County approving the general building permit. Mull remains in communication with Elbert County staff and will secure all necessary permits from the county upon approval of this OGDP as per the direction of county staff. MUL estimates it will take approximately 5 days to construct this well pad at the proposed location. The drilling of the well is estimated to take approximately 19 days. This is a very conservative estimate for drilling operations and does include rig mobilization time. Interim reclamation will most likely occur in mid-2025. Specifically, MUL has targeted the first growing season after the well is on production as the best time frame in which to commence and complete interim reclamation activities. MUL currently anticipates commencing operations upon approval of all required permits. MUL's mission is to responsibly and beneficially build and maintain energy assets in an ethical and environmentally responsible way. MUL strives to be a responsible steward of the environment and be a part of the communities in which they do business. We would like to highlight just a few of the best management practices they've committed to as a part of furthering that goal here on this slide. To protect public welfare and wildlife, MUL will utilize temporary lighting during drilling. These lights will be downcast and directed to task areas only. There is no permanent lighting proposed for this location. To provide environmental protections, MUL will install silt fences and straw wattles around the location for stormwater controls. MUL does not anticipate the well to produce natural gas in quantities beyond what can be beneficially used on location. But should the well produce beyond what can be used on site, MUL will submit a revised gas capture plan via Form 4 outlining the disposition of this excess gas. And additionally, only fresh water will be used for dust mitigation. MUL has designed the Williams OGDP to protect public health, safety, welfare, and the environment by minimizing impacts on cultural and environmental receptors. The project will incorporate their decades of operational experience to execute the project safely while minimizing potential impacts on public health, safety, welfare, wildlife, and the environment. And with that, I will turn it back over to Mr. McGowan.
Thank you, Jessica. Thank you, commissioners. Again, we appreciate your time today. We respectfully ask this commission to enter orders establishing an approximately 320-acre drilling and spacing unit for the application lands, authorizing one vertical well within the drilling and spacing unit for the production of oil and gas and associated hydrocarbons, finding that the OGDP and associated 320-acre DSU will prevent waste, protect correlative rights, maximize the efficient and economic production of the formation and the application lands, and will result in development that will protect and minimize adverse impacts to public health, safety and welfare, the environment, and wildlife resources, and will protect against adverse environmental impacts on any air, water, soil, or biological resources in compliance with CRS 3460-106. That the granting of this application is in accord with the Oil and Gas Conservation Act, found at CRS 3460-101 at all, and for such other findings and orders as this commission may be deemed proper and appropriate or advisable in this situation. This concludes our presentation. We are happy to answer any questions at this time. Thank you very much.
Great, thank you for the presentation. If we could stop the screen share, I'll be able to see everybody a little bit better. Great. Commissioners, do folks have questions for Ms. Donahue or the panel from the Wichita Conference Room? Commissioner Messner?
Thank you, Mr. Chair. Appreciate the presentation and the application. I just want to make sure that there's clarity here. You had a slide that talked about what would happen if you encountered natural gas that's not entirely utilized by on-site production equipment. And the BMP, as I read it in the Form 2A, is should MUL encounter natural gas that is not entirely utilized by associated production equipment, the well will be shut in, and then a revised gas capture plan will be submitted via Form 4 outlining the disposition of excess gas. And so just wanted to confirm that you understand that.
Yes, Commissioner. Thank you for the clarification. MUL will shut in their well while they revise their gas capture usage.
Thank you.
Further questions for the panel? Pretty straightforward. Do we want to move to deliberations? Does anyone desire to make a motion? Commissioner Messner?
Thank you, Mr. Chair. I will make a motion. I just want to make a comment that understanding that this operator has experience with these type of wells in these particular location, and that they don't typically find natural gas as part of the wells that they're drilling. From my perspective, should they encounter even de minimis amounts of natural gas that aren't contemplated, that gas capture plan cannot include venting or flaring of that natural gas. And I think that that's an important understanding, that there will have to be a gas capture plan that utilizes that in a beneficial way. And so, especially in a situation where it is that they're willingly and knowingly drilling this well without gas takeaway. And so I want to emphasize that, but understanding that that's part of the BMPs that are associated with the Form 2A, that I will move approval of this application.
Second. Motion and a second. Is there any further discussion from commissioners? All right, seeing none, all those in favor of the motion signify by saying aye. Aye. Any opposed? Motion carries. Thank you to our staff for the work here. Thank you to the applicant, and your OGDP is approved.
Thank you, Mr. Chair, commissioners.
Thank you, commissioners.
Thank you, commissioners.
Thank you.
Thank you.
Thank you, Wichita Conference Room. All right.
Thank you.
Any further business before us? Seeing none, I look for a motion to adjourn. Several motions in several seconds. All those in favor of adjournment signify by saying aye. Aye.
Aye.
Any opposed? Motion carries. We are adjourned. Have a good day, folks.